The United States Supreme Court has just handed down an immediate emergency block, and this order carries some truly massive nationwide and constitutional implications. In a matter of days, the highest court in the country intervened in a fight that had already thrown a federal regulatory framework into chaos, froze a lower court ruling before it could take effect nationwide, and once again exposed a bench that is deeply, deeply divided. So today we need to break down exactly what the Supreme Court did, how we got here, why the justices themselves are fighting over this, and what happens next, because trust me, this is far from over. Let's start with the actual mechanics of what just happened, because the legal maneuvering here moved incredibly fast. This entire fight centers on mifepristone, the medication used as part of a regimen to end pregnancies, and more specifically, on the rules that govern how it can be prescribed and delivered. Back in 2021 and again in 2023, the FDA formally lifted its old in-person dispensing requirement. That change meant patients could be prescribed the medication through telehealth, have it filled at a retail pharmacy, and have it shipped straight to their door through the mail. For the drug manufacturers and for patients relying on this system, that framework has been the operating reality for years now. But the state of Louisiana was never on board with that. Louisiana had already passed its own state-level restrictions on the medication, and it went to court arguing that the FDA's mail-order rules were arbitrary, that they were unlawful, and that they were actively undermining the state's own sovereign authority to regulate healthcare within its borders. This wasn't just a policy disagreement. Louisiana filed suit under the Administrative Procedure Act, and the case, Louisiana versus FDA, became a direct legal test of whether a single state can force a change to a federal agency's nationwide distribution rule. Now here's where it escalated fast. On May 1st, a panel at the Fifth Circuit Court of Appeals ruled in Louisiana's favor. And this wasn't some narrow, limited decision. The Fifth Circuit's ruling functioned as a sweeping restriction on mifepristone access, effectively rolling back telehealth prescribing and mail delivery, not just in Louisiana, but as a nationwide matter. If that ruling had been allowed to stand and take immediate effect, it would have instantly reinstated in-person dispensing requirements across the entire country, upending a distribution system that manufacturers, pharmacies, and patients had relied on for years. The drug manufacturers at the center of this, Danco Laboratories and GenBioPro, were not about to let that ruling take hold without a fight. Within days, both companies filed emergency applications with the Supreme Court, warning the justices that allowing the Fifth Circuit's order to take effect immediately would create massive disruption, not just for their own operations, but for the entire national distribution system built around this medication. They argued the harm would be immediate and irreversible if the court didn't step in. And this is where we saw the first crack in how the justices were handling this. Just 3 days after the Fifth Circuit's ruling, on May 4th, Justice Samuel Alito, who oversees emergency applications coming out of the Fifth Circuit, granted a short-term administrative stay. That's a temporary procedural move. It doesn't decide the underlying legal question, it simply presses pause and buys the full court time to review the briefs and make a real decision. So at that point, mail-order access to mifepristone stayed in place while the justices deliberated behind the scenes. Then, on May 14th, the full Supreme Court weighed in with its actual ruling on the stay applications in the consolidated cases, Danco Laboratories versus Louisiana and GenBioPro versus Louisiana, and the court granted the stay. That means the Fifth Circuit's sweeping nationwide restriction has been frozen. It cannot go into effect. The FDA's telehealth and mail order framework stays intact, at least for now, while the underlying legal fight continues to work its way through the courts. But here's the part of this story that you really need to pay attention to, because it tells you everything about where this is actually headed. This was not some quiet, unanimous procedural order. Justices Clarence Thomas and Samuel Alito both dissented from the decision to grant the stay. Two of the most influential conservative justices on the entire court looked at this emergency application and said, no, we would have let the Fifth Circuit's restriction take effect. That is a significant public fracture on an issue this high profile, and it tells us that even though the manufacturers won this particular round, the deeper legal battle is nowhere close to settled. Think about what that dissent actually signals. When you have justices publicly breaking from the majority on an emergency stay, especially in a case this politically charged, it's a preview of how contentious this fight is going to be once it comes back around for a full merits review. It also tells us something about the underlying tension on the court. There is real disagreement here over how far the practical harm to drug manufacturers should factor into decisions like this, versus how much deference should go to a state's own claims about protecting its regulatory authority. Now, to really understand why this case matters so much and why people across the entire political spectrum are watching it so closely, you have to zoom out and connect it to the bigger picture. This is playing out in the direct aftermath of the Supreme Court's landmark ruling in Dobbs versus Jackson Women's Health. When the court overturned Roe versus Wade in that decision, the majority was explicit that authority over abortion regulation was being sent back to the states and to the people's elected representatives. That was the entire premise of the ruling. But what Dobbs didn't clearly settle is what happens when state authority collides with a federal agency's own nationwide rule. That's exactly the gray area Louisiana has been operating in. Louisiana's argument at its core is that the spirit of Dobbs gives states the power to block outside entities, in this case out-of-state pharmacies and telehealth providers, from shipping this medication to residents within their borders, even when the FDA itself has approved that exact distribution method nationwide. So this case isn't just about one drug or one state's law. It's a test of whether a single circuit court, ruling in a single case, can functionally rewrite a federal agency's regulatory framework for all 50 states at once. That's the constitutional question sitting underneath all of this. Can a state use an administrative lawsuit to force the federal government to unwind a policy that applies nationwide? And can a regional appeals court, covering only a handful of states, issue a ruling that reaches into every other state in the country, whether those states support the underlying policy or not? Those questions go way beyond mifepristone. They go to the heart of how much power lower federal courts actually have to set national policy through litigation, and that's exactly why this keeps landing back at the Supreme Court's doorstep. Which brings us to the mechanism that's been drawing so much scrutiny lately, the court's emergency docket, sometimes called the shadow docket. This is the fast-track process the Supreme Court uses to handle urgent applications like this one, typically without full briefing, without oral arguments, and often without a detailed written opinion explaining the majority's reasoning. Historically, this process was reserved for things like last-minute stays of execution. In recent years, it has become the primary battlefield for some of the most consequential legal fights in the country: immigration policy, executive power disputes, and now, once again, reproductive health care regulation. What makes the emergency docket so unpredictable is exactly what we saw play out here. A sweeping nationwide rule can be reinstated, blocked, frozen, or unfrozen within the span of about 2 weeks, based on a handful of justices weighing in with minimal public explanation. One circuit ruling on May 1st, an administrative stay on May 4th, a full court order on May 14th. That is an incredibly compressed timeline for a decision with this much national reach, and it shows you just how quickly the legal landscape around an issue like this can shift with almost no warning. So where does this actually go from here? The Supreme Court's stay does not resolve the underlying case. It simply freezes the Fifth Circuit's ruling and keeps the existing FDA framework in place while the full legal process continues. That means this case now heads back down to the Fifth Circuit for a complete merits review, a full hearing on the actual legal arguments, not just an emergency pause. And once that appellate review wraps up, whichever side loses is almost certainly going to push this straight back up to the Supreme Court, this time for a full decision on the merits, not just an emergency stay. Given how fast this case has already moved and how much national attention it's drawing, there's a real possibility this ends up back in front of the justices for a complete hearing within the next term or two. And if it does, you can expect this fight to intensify significantly, because now the court won't just be deciding whether to pause a lower court ruling temporarily. It will be deciding, once and for all, whether a state can override a federal agency's nationwide regulatory framework in the post-Dobbs legal landscape. That is an enormous question, and based on the fact that Thomas and Alito were already willing to let the Fifth Circuit's restriction take immediate effect, we already have a strong signal that this eventual ruling could be very close. There's also a broader pattern worth flagging here. This isn't an isolated dispute. It fits into a much larger wave of litigation where individual states are testing exactly how far they can push federal preemption arguments in the years following Dobbs. Louisiana is essentially arguing that state-level authority over reproductive health care should extend far enough to reach outside entities operating entirely within federal law. If that argument eventually succeeds at the Supreme Court, it wouldn't just affect mifepristone. It could open the door for states to challenge all kinds of federally approved nationwide distribution systems whenever those systems touch on an issue the state has chosen to regulate more aggressively. That's the kind of ripple effect that goes well beyond any single medication or any single state. On the other side, if the eventual ruling favors the drug manufacturers and the FDA's existing framework, that would reinforce the idea that federal agency approval generally preempts a state's ability to block a nationally authorized distribution method even when that state strongly disagrees with the underlying policy. Either outcome sets a major precedent, and either outcome is going to reshape how these state versus federal fights play out across the country for years to come. For right now, the practical reality is this. The Supreme Court's emergency stay means the existing system stays in place. Mail order and telehealth access to mifepristone remains intact nationwide while this case works its way through a full appellate review at the Fifth Circuit. Nothing about the underlying legal dispute has been resolved. This was a pause, not a final answer, and the fact that two justices were willing to let the more restrictive ruling take effect immediately tells you that the eventual final decision is going to be closely watched and very possibly closely divided. So here's what to keep an eye on going forward. Watch for the Fifth Circuit's timeline on the full merits review, because how quickly or slowly that moves will tell us a lot about when this case could realistically return to the Supreme Court. Watch for how the manufacturers and the state of Louisiana frame their arguments once this moves into full briefing, because that will show us exactly which constitutional theories each side is leaning on heading into a merits fight. And watch the rest of the court's emergency docket this term, because this is clearly not the only high-profile fight testing the outer limits of state authority after Dobbs. And the pattern we're seeing here, a fast emergency filing, a temporary administrative stay, a divided full court order, is quickly becoming the norm rather than the exception. Let's also talk about why the timing of this ruling matters so much, because context here is everything. This case landed on the court's emergency docket during a stretch where the justices have already been fielding an unusually high volume of urgent applications. Legal observers have pointed out that the number of these emergency filings has climbed dramatically over the past couple of terms compared to prior administrations, and a huge share of them involve exactly this kind of question. How much power does a single federal court have to freeze or reshape a nationwide policy while the underlying legal fight is still being litigated? So this mifepristone dispute isn't happening in a vacuum. It's landing on a docket that is already stretched thin, already drawing criticism for moving fast and explaining little, and already under a microscope for exactly the kind of terse, unsigned order we saw here. And that criticism matters because when the court resolves a case of this magnitude through the emergency docket, the public often gets very little insight into the actual reasoning. There's no full oral argument. There's no lengthy majority opinion walking through the constitutional analysis step by step. What we get instead is a short order granting the stay, plus whatever the dissenting justices choose to write on their own. That's exactly what happened here. Thomas and Alito dissented, which means we at least got some insight into why they disagreed, but the majority's own reasoning for granting the stay was not laid out in the same kind of detail you'd expect from a full merits decision. That's the trade-off built into this entire process, speed over transparency, and it's a big part of why the emergency docket keeps generating so much debate. Now let's talk about the players on the ground, because this fight isn't just an abstract legal dispute. It has very real consequences for the people and companies caught in the middle. For Danco Laboratories and GenBioPro, the manufacturers behind this medication, a sudden nationwide reversal of the mail order framework would have meant an immediate operational nightmare. Distribution agreements, pharmacy partnerships, telehealth provider networks, all of that infrastructure has been built around the FDA's current rules. Forcing an overnight shift back to strict in-person dispensing wouldn't just be disruptive, it would functionally cut off access for a large number of patients who currently rely on telehealth prescribing, especially in states where that's the only realistic option available to them. For the state of Louisiana, the stakes are just as significant, but from the opposite direction. Louisiana has already taken the position, through its own state laws, that it wants tighter control over how this medication is accessed within its borders. From the state's perspective, the FDA's mail-order rules aren't just a federal policy choice. They're an end run around the very state authority that Dobbs was supposed to restore. So when the Fifth Circuit sided with Louisiana, the state saw that as a validation of its core argument, that a state's regulatory power doesn't stop at the mailbox, and that out-of-state entities shouldn't be able to bypass state law just because they're shipping through a federally approved channel. That's the exact collision course this case is on. And it's why neither side is going to walk away from this fight, regardless of how the emergency stay came out. The manufacturers got the outcome they wanted this round, keeping the existing distribution system intact while the case continues. But Louisiana hasn't lost anything permanent either. The underlying Fifth Circuit ruling is paused, not overturned, and the state still has a full appellate process ahead of it to make its case. It's also worth noting how unusual it is for a case to move through the system this quickly. From the initial Fifth Circuit ruling to the administrative stay to the full court's decision on the stay application, this entire sequence played out in under 2 weeks. Cases that eventually reshape national policy typically take years to work through the full briefing, argument, and opinion process. What we're watching here is the compressed high-speed version of that process, where the initial outcome can be decided in days, even though the deeper constitutional question underneath it all could still take another full term or more to resolve completely. This is a case that started as a dispute over one state's regulation of one medication, and it has turned into a genuine test of federal preemption, agency authority, and the practical limits of Dobbs in the years since that ruling came down. The emergency block is in place. The manufacturers got their pause. But with Thomas and Alito publicly dissenting, the deeper fight over who actually controls this policy, the states or the federal government, is still very much unresolved. And it is almost certainly heading back to the Supreme Court for a real final answer. We'll be tracking exactly how this develops as the Fifth Circuit takes this back up. And as always, thank you for watching and for taking the time to actually understand what's happening behind these headlines instead of just reacting to them.